important in our country. The first one, it is less expensive, it is simple, it is informal. We know that court procedures require a court fee. They might get expensive. Not everyone might have that sort of money. But since it is a departmental thing, administrative tribunals may or may not levy such fees on the parties. It is simple and informal procedures. Court procedures are formal. They have to be followed very strictly. Otherwise, we might have repercussions. But that is not the case in administrative tribunal. They are informal. They are simple. Might not need a very elaborate procedure. Next one, they are cheaper and more accessible. Like I already said, they are cheaper because it is within the department. More accessible because you can always go to the composition of the members and request. It's not always as busy as the courts. Next one, courts questions are decided subjectively. Since each administrative body is concerned with their own department, they know what is better. It deals with that particular subject. But when you come to courts, it decides based on objectively. Okay, so that is here it is more intricately decided. Next one, expert disposal of claims. Since we have already seen a composition of experts, we know that whatever disputes, they know the matter, they know the situation, they know the conditions of why a certain cases arising in a department, and that is why they are able to dispose it in a very proper prim way. Next one, rapid action. Since it is happening within the department, since they might not have many cases to deal with, they are going to act rapid. Like everything, definitely the administrative tribunals also have disadvantages or something called as limitations. First one, it is against the rule of law. The rule of law says that everyone must be heard equally, everyone must be given an opportunity to have their share of say. But sometimes the tribunal itself, when it is a party to the dispute, the rule of law is compromised upon. Next one, inconsistent and no precedence. Every department, though it works differently, if a committee is constituted, not every committee might have the similar judgments or similar awarding of the cases, right? So it becomes inconsistent. Today, a committee is set up for some case. A few years later, a similar problem arises. Another committee is set up. They might or might not look into the same precedents. So there is inconsistency. There is no uniformity. There is no uniform procedure. The courts, if you see, though they are strict rules, they have a uniform procedure for everything. Here in the administrative tribunals, we do not find it. Next one, independence of judges is not the same. In courts, we see that the judges are given absolute independence to work, investigate upon the facts of the cases, upon the evidences. But here, we see that all the members are appointed by the people working in the administration, right? So it might become a bias, and the judges or the chairperson, vice chairperson, the persons who are deciding upon the disposal of the case might become a little under the administrators. Experts might not have a legal background. We see one judicial minister, but the rest of them might or might not have a background in law. They might not know how the judicial procedures work. So that becomes a very big disadvantage. The last one is the summary trials. In order to quickly dispose the case, we often see the administrative tribunals tending to directly vote for summary trials. In summary trials, it is again the rule of law is compromised. It is very extremely speedy. We do not know what is going to happen. We do not know what is the next course of action in the case. So these are the disadvantages when it comes to administrative tribunals. Coming to how a court is different from an administrative tribunal, the court judgment given is by the courts is called an order, while an administrative tribunal's judgment is called as an award. Another disadvantage or difference you can add to this is that judges are very impartial when they are working in courts. But most of the chairperson, vice chairperson we see here are retired judges. So what it becomes is, in term of their office, in lieu that they might be appointed as chairperson or judge for any of the administrative tribunal, what they become favorable to one part of the government while they are in service. So next one, the courts have the authority to decide upon the legislation of a particular act, the validity of a particular act, but the administrative tribunals do not have any such rights. So courts are also appealable further, like the lower courts can go to the high court to the Supreme Court. The same is the case with the administrative tribunal, but one disadvantage is that a body which was primarily set up for the concept, under the concept that to reduce the burden of judiciary, if you are giving them a further provision for the appeal, the entire purpose of setting up an administrative tribunal is lost. So, as a conclusion part, I would say that administrative tribunals, the concept of setting them up was very essential and still continues to be essential, because many cases are disposed at departmental and state levels, which will help the courts to focus more on much bigger issues, much important issues which need immediate actions. Administrative tribunals have also given awards which have become precedents for few other major court cases. So that is why administrative tribunals is a major part of administrative law as well as in the functioning of a judiciary of a country.